right, now we come to the next presentation, and that's the presentation under the title Control of Standard Terms in Energy Performance Contracts. And the presenter is Emine Meliknur Kiliç from İzmir Bakırköy University, Turkey. Yes? So, the floor is yours.
Thank you, Mr.
You can start, and don't forget you have 15 minutes.
Yeah, of course. Okay, my name is Emine Meliknur Kiliç.
Wait a moment.
I'm sorry.
Yes, because we have also our online
okay.
guests, yes?
Yeah, but can we please wait a bit? Okay. I'm not fond of that.
Okay.
Yes. Okay. Thank you. Hello.
Speak to the microphone.
Okay. I'm Emine Meliknur Kiliç. I had my LLB degree, bachelor degree and LLM degree at Istanbul Bilgi University, and having my PhD degree at 9 Eylül University. Now I'm a research assistant at İzmir Bakırköy University. So, but this is not the one. This is the last year's. It's a break, right? It's not in 15 minutes. So...
It's not the correct presentation,
No, it's
yes?
not.
So, another PPT.
But I can keep talking. Thanks to the organizing team and the scientific committees for such as amazing conference. And
continue, please.
Okay.
Yes.
My outcomes occurs from my visit to LLM Munich during my predoctoral research. So I would like to thank to Professor Stefan Lorenz and the Scientific and Technological Research Council of Turkey, TÜBİTAK, which give me the scholarship for that research.
Okay, I think that now is the right one, yes?
Yeah.
Sometimes, yes. We know that it's very human to make mistakes, yes?
Yeah.
Okay. So, please continue,
Yeah,
and don't be so nervous, yes? We are
yeah,
supporting you
okay.
very much.
Yeah,
I think the
thank you.
topic is interesting, and we are listening to you carefully.
Yeah, the context and the aim. Energy performance contracts are widely used in public and private sectors to promote energy efficiency and renewable energy generation. These contracts are usually long-term, technically complex, and involve substantial investment. Because they are drafted by specialized companies, they often appear as standard form contracts. So they live in one party, often the client or employer with limited bargain power. The aim of this study to examine whether certain standard EPC clauses comply with fairness standards in Turkish law by utilizing German legal practice. So, what is an... Oh, sorry. Yeah, we have a presidential degree, dated, which is important, but I have no time to talk about it. And what is an energy performance contract? In EPCs, the contractor guarantees measurable energy saving. The client pays based on performance. Legally, it's a hybrid work of service and work contracts. The problem, however, is that the EPCs are almost always based on standard documents, so the clauses are not negotiated, and the client's ability or knowledge is minimal. Thus, the influence of the client or employer is also minimal, often none. And what is standard contract terms? They are pre-drafted and not individually negotiated. Control of the standard contract terms aims to protect contractual balance, ensure transparency, and prevent the misuse of contractual freedom in situation of unequal bargain power. And the three stages of the control according to Turkish law: validity control, which usually checks if the other party was properly informed and consented to the terms. Interpretation control, it's the principle comes from Roman law, so Turkish law based on Roman law. Uncertainties are read against the drafter to protect the weaker party. And content control, which is my favorite, based on good faith, ensures the clauses don't create unfair imbalance. And the Turkish law, also many of the European law, follows the German model because of the AGBGG. German model, but its protective scope is wider because we have less codification, but narrower for legal practice because we are still trying to figure it out. And there would be many cases if the articles would use properly. Especially in B2B contracts, we have still problems in Turkey. So comparison to German law, I will cut it short. Key difference in short. In Turkish law, consumer contracts receive separate security while other contracts fall under the code of obligation. Yet in practice, courts often overemphasize the prudent merchant principle that limiting the protection of merchants and narrowing the content control, especially B2B contracts. So, what is the prudent merchant? We are seeing a Polish merchant. So, it's a principle which is in the Turkish Code of Commercial. Prudent merchant is the most rational one, while every act of his. So the Supreme Court often limits the standard term control between merchants on this basis. And the courts, how we solve this problem, the courts should examine each specific case individually rather than making assumption on knowingly acting of merchant. Even if the employer or client is a merchant, EPCs may not be within their field of work, or maybe they are unfamiliar with these contract clauses. So every case should be checked by every scenario is checked by case. Yeah, and let's come some case examples. First of all, you see there's TEDAŞ. TEDAŞ refers Turkish Electricity Distribution Company. In our case, it is the third-party administrative approval office. And this article regulates defects notification, warranty, and delivery of the contractor. So this is an important article, that's why. Here the warranty starts before TEDAŞ official acceptance, so the client cannot start to use the work even it's delivered by the contractor. This is a problem for the employer. So here's the conflict of interest occurs. Contractor, in that article, contractor might want to make the delivery to avoid the risk of damages, loss due to a delay caused by third party, the administrative office. And employer's interest here is early start of result of delivery. We are talking about period of time, such as defects notification and warranty. So, but there is no actual delivery. So, what is our proposal to make this article, make this term became more fair for both parties? This clause offers a balanced provision. And I should have said that, sorry, there's an BGH decision about this article, this scenario. So it says that if you make it start, it should be seeable for the employer, so it would be fair for both parties. So For the basis of BGH decision, this is the most balanced provision. It ties the warranty period to actual acceptance, preventing unfair shortening. At the same time, it protects the contractor from indefinite delays by requiring the employer to complete acceptance within a reasonable time. Here I accepted 30 days after a written request. Since the delay is neither because of the contractor nor the employer, it's the third party's issue. After a written notification of the contractor, if not, hasn't made it by the third party, the warranty starts automatically. Thus, the clause ensures predictability, fairness, and the good faith, keeping EPC both enforceable and practical for the parties. And let's check the second example.
5 minutes.
Yeah, it's enough. This clause on maintenance lack of transparency. It makes the employee pay from the third year onward, but refers unclearly to another document. Since it leaves price and scope undefined, it gives the contractor unilateral power. But we don't want unilateral power for the contracts. Such wording would breach Article 25. Turkish Code of Obligation, and fairness and transparency, and violates provision of the unilateral chains. Here you can see the codes from both Turkish law and the BGB. In EPC contracts, where maintenance is a major long-term expense, so this is a lack of clarity unfairly shifts the risk to the employer. And there's also creates a conflict of interest. What is our proposal? Here, reserve with maintenance clause may meet the control standards. So it links fee updates to objective parameters, ensuring transparency and predictability. It clearly defines the scope of service and prevents unnecessary changes to the annex. Thus, to achieve fairness, balance, and legal compliance while keeping EPC efficient and practical. Key findings, I have mentioned them many times, so I will keep them. I will keep to the conclusion. Come to the conclusion. To conclude, standard terms control is not just a consumer tool, but a means to ensure transparency, predictability, and trust in long-term contracts, ensuring competition among market actors, because it's a matter of preventing unfair competition. The fairness of EPCs depends on effective control. However, Turkey's prudent merchant approach remains too rigid, quite rigid, and defines perfect conditions which is quite distant from real ones. So standard contract terms control would strengthen EPC market credibility and balance efficiency with fairness in the renewable energy era. It would be better Turkish courts to strengthen an approach that align with commercial practice and safeguards good faith and unfair competition in merchant relations. So, yeah, thank you for listening me. Okay. If any questions.
Thank you very much. I know it's very hard just to present so complicated problems in such quiet time. Yeah. But thank you for the time discipline. It was really multi-dimensional, presentation.